Yeah.
Yeah, it kept messing with me. Not only is it not accurate to the minute, it's also not accurate in the hour.
What time is it?
It's 1:24.
Oh.
You're live. Again, welcome back, folks. This is the Joint Justice Oversight Committee, and we're running a little bit late this afternoon, but we're going to start with our legislative counsel, Ben Novogradzki, giving us just a quick overview of the pretrial supervision program. We had a little bit of this earlier, and we have to make a decision on some of this or not.
Right.
Right?
Well,
I don't remember.
kind of. Yeah.
This is a pretrial supervision program also that is going to be, it was moved from Essex County to Chittenden County for the 3B court docket. So.
Chairman, do you want me to present on the screen or just follow along? What's your preference?
Follow. What about folks who are on Zoom? Do you want to see it on the screen? I would assume.
It would be good to have it on screen.
Okay.
Okay.
Yep.
Let me log on now.
Also, we had David Demore give a presentation with some issues because Council of State Governments was overviewing the pretrial supervision program in Essex. And they also had some recommendations on how to tweak the statute.
Yeah, they should be submitting a report on that. If that's
Yes.
draft report that they're gonna finalize.
And is it based on Essex?
Based on the pilot.
Do they know that it's switched?
They do know that there's the expansion for it.
Okay.
Okay, I will share my screen. Presentation mode. You're good. Okay. Good afternoon. For the second to last time, Ben Novogradzki of Legislative Council. I'm here to talk.
The dark side.
Well, if it gets too dark, I'll come to your committee room for refuge, right?
House Human Services always has a spot for you.
Oh, thank you. So just to provide a brief overview, hopefully, of the pretrial supervision program, which everybody has, heard through adjacent testimony at this point. So a quick overview of the program. It's governed by 13 VSA 7555. This was passed 2 years ago. And revived this statute, but with new substance. The pretrial supervision program is imposed as a condition of release under 13 VSA 7554. Only certain defendants are eligible. We'll get into the eligibility. It's a court-ordered program. It's administered by the DOC, so they're the ones that are really boots on the ground. And there's also a compliance and review procedure, which were some of the areas that CSG had identified for improvement. So again, just going into the governing statutes a bit more, 13 VSA 7554 governs release prior to trial. So this is essentially, it's the bail statute. Court assesses various factors to determine if conditions of pretrial release need to be imposed. There's a slew of factors that are contemplated by a judge, risk of flight, seriousness, how many offenses, past compliance with court orders and appearances in criminal prosecutions, among others, that the court assesses to determine the scope of any pretrial conditions that need to be imposed on the defendant. Pretrial supervision was a new condition added to those. Which is again governed by 13 VSA 7555. And the overall purpose of the program is twofold: to assist eligible people to improve pretrial compliance with their conditions of release, and then to coordinate and support the provision of pretrial services when appropriate, again, to ensure attendance at court appearances while awaiting trial. Any questions on the statutes? Eligibility criteria is two. One, the defendant has to be accused of violating conditions of release pursuant to 13 VSA 7559. That's what we were discussing a bit earlier about a new charge that would be filed. Or the defendant has to have at least 5 dockets pending against them. So those are the two eligibility criteria, and then there's an assessment that's done if you meet that eligibility criteria. And that procedure includes, it can happen at arraignment or a later hearing, where any party or the court can move to have an eligible defendant reviewed to determine whether placement's appropriate. The review is scheduled upon a DOC report. So essentially between the time that the review is asked for and the scheduled hearing date, DOC would do an assessment recommending certain levels of supervision. The court would then review that report, schedules the hearing to determine the appropriate placement, and ultimately it's balanced against whether placement in the program would reasonably ensure the defendant's appearance in court, reasonably mitigate against the risk of flight from prosecution, or reasonably ensure protection of the public. And the court considers the nature of the violation, the nature and circumstances of the underlying offense, any prior conditions, so essentially criminal history and mental health needs as well, any risk or undue burden to third parties or risk to the public safety that may result from placement. Essentially, we don't want to put people in the community or back in residences that would endanger victims or the public generally. And then finally, sort of a catch-all, anything else that the court deems appropriate can be factored into this assessment. So any questions about the considerations that the court undertakes when assessing the appropriateness of placement into the program?
For folks who are on Zoom, I cannot see you, so I'm going to depend on Megan to let you know if your hand is raised. No hand.
Moving on, what are the supervision levels? There's the telephonic monitoring system, telephonic meetings with a pretrial supervision officer. So the difference between those two, the monitoring system are essentially reminders to appear in court, or any automated reminder that DOC has set up for you. There are those telephonic meetings with an actual human, the pretrial probation officer or supervision officer, or an in-person meeting, electronic monitoring, or any other means of contact deemed appropriate. You'll see in the CSG presentation, they kind of build out what those 3 supervision levels are. And I don't know if I want to steal, Isaac, if you had any thunder. But it's essentially a smattering of what you see here. There's just sort of an assessment rubric that's attached to it as well. I can get into that if you want, but it's kind of granular. So compliance and review. Under the current structure, pretrial supervision officers must notify a prosecutor and use reasonable efforts to notify the defendant of any violations of court-imposed conditions. They have the discretion to notify the prosecutor if there are violations of department-imposed conditions. So the difference between those would be, for a department-imposed condition, if you're under electronic monitoring, keep your electronic monitor charged. So that would be an administratively imposed condition that's not court-imposed. But a court-imposed condition would be potentially stay away from the victim. If they didn't do that, then that's a required report to the prosecutor. Either party or the court can move for the court to review the defendant's pretrial supervision conditions if there is a report, or even if there isn't. If, let's say, the individual has been compliant, the defense may move to remove them from the pretrial supervision program because they've shown compliance, or vice versa. If they haven't been, maybe something more needs to be done. And then finally, if someone has absconded, the prosecutor may file a sworn affidavit with the court to issue an arrest warrant for someone that fails to report, commits multiple violations, or absconded in general. Now, there has been discussion about sort of the bottleneck that this current system creates, where there have been violations reported, but there's a backlog with our prosecutors, and essentially these violations are sitting on their desk and aren't being adjudicated, which is one of the recommendations that CSG has discussed, and I'll get into that in a second. There are also policies, procedures, and program support that were created as part of this program. So DOC established written policies and procedures for use by the department, its contractors, and to help with the courts in understanding the program as well. It developed procedures and policies about the supervision levels and the evidence-based criteria that goes into it, and the means of contact appropriate for each level. And they have the ability to engage with a public entity that meets its criteria to assist in operating the program. I believe this is how CSG got involved to a degree, is that they, or at least they represented that DOC had been in contact with them to assess the program. And then again, it's contingent on funding, which is why it's essentially a pilot at the moment, because there wasn't enough to fund it statewide. And that's why we had it in Essex initially, and now moving to Chittenden County.
Yeah, there was 600,000 put in for the FY25 budget. And I'm not sure, I don't think there was any money put in FY26. Was there another 600,000? Because it was, the initial cost was around 1.1, 1.2 million.
So this is a portion of CSG's report about ways to strengthen the program and improve it. One, they recommended.
This before it just came out? Is this the one that just came out?
These are the slides they presented.
Yeah, well, in July, I believe.
Yeah, they have a written report, they will be submitting.
Yeah, so this is from July 16th. So you should all have this. It's been presented, but I just wanted to kind of highlight some of the recommendations that they thought may be appropriate. One is to increase the frequency and intensity of contacts, including in-person interactions. Their justification for that is the significant mental health, substance use, and housing and employment uncertainty. The more the interaction, both in frequency and intensity, will help mitigate those issues. The other one is what I already mentioned about authorizing DOC staff to make direct referrals to the courts to essentially bypass that administrative step of going through the prosecutor. That way it would, in theory, expedite the process and hold people accountable faster. Also, to provide more opportunities for DOC to interact with the courts and adjust program conditions based on client progress. So they would recommend directing DOC and the courts to develop a process that would promote that and really increase communication between supervision officers and the judge, all to really support the defendant's success and to give officers more flexibility into determining what's needed.
So Ben, I think we have a question.
Yeah, quickly, back up the next one, Ben, if you would. DOC bypassing the state attorney's office and going directly. What is that process? Is that direct file?
Be a direct file.
Affidavit or?
Well, it could be whatever you want it to be quite honest, because
What they want it to be, DOC.
well, they didn't get that specific. It may be in their forthcoming report. But I mean, it could involve an affidavit, or it could just be a motion filed by the department. I think, in previous, not in this program, but in home detention before it was changed, there was this ability to have DOC go right into the court to say, okay, we need to pull them back from home detention and revoke them. But Isaac, you may be able to speak more about what was included in that process, because it could be a model in this.
Yeah, thanks, Ben. I think just to speak very generally, the department is just, we are subject matter experts, folks who have been involved in the pilot, out of the Newport PD office, now out of Burlington. I think they're really focused on the front end, the back end. Those are where we need changes for DOC. We need to be able to refer people into the program, because currently we do not have that discretion, but sometimes we know these individuals better than anybody else. And we have the subject matter expertise, we think they would do well in this program. So currently, we will be looking for that statutory change. And then on the violations piece, I think we can figure out, technically what might work best. But the department feels that the entire purpose of pretrial supervision was, as we've kind of talked about with the 3B document, try and really narrow down time between some kind of violation and a response. And so the fact that we sometimes have these violations that just sit on a desk for weeks and weeks, that deterrent effect is really nullified. So what we're looking for is to allow the department to directly make those violations to the court.
So it's pretty open at the moment. No, I mean, but that's the policy decision that's in front of all of you.
To make this come in session.
Yes.
Topper?
Yeah, under two there,
Mhm.
that the Department of Corrections should notify. Is there a reason they would use that word should?
Well, this is just their recommendation. They think it's appropriate
Yeah.
for them to do so. So it's not, this isn't the current program right now. It would just be.
Yeah, that's what they recommend.
Exactly.
Are they recommend, that's what I was trying, is there a reason to use that word, Melinda, instead of must?
Yeah, I mean, I think that's just probably a better question for Dave Demora at CSG.
Okay,
But the way that I read it is that they want them to notify.
yeah,
So,
if we're trying to get this thing moving.
right. But if you want it to be required, that's a policy decision that you could make
Yeah.
if and when a bill is presented.
So right now, the way the pretrial supervision is going to work, because it got shifted to Chipman for the 3B court, that if a person is sent to a pretrial supervision and there is a violation of one of those conditions, the DOC right now, by current law, notifies the state's attorney. So under this pilot project, because the state's attorney that's there is to focus on these folks, in theory, would not have that delay. Would go, in essence, be acted on pretty quickly. But if we go back after the pilot project, we go back to whatever's in place right now. When DOC says there's a violation, goes to that state's attorney in that county, then it's gonna get backed up.
Yeah, and maybe
So
this,
you can't use the pilot project as a gauge if this program works or not, or that particular piece of current statute works or not, because you've got a dedicated state's attorney in the Chittenden pilot project specifically for these folks, which is not the case for other counties.
and maybe maybe this answers your question more directly, is that in the process that they suggest, it would bypass the state's attorney. So theoretically, they're just making sure that the state's attorney is aware that there would be a motion for someone to be violated, just so that the parties are aware of everything that's going on with the case.
That's a recommendation that the Council of State Governments is making, that we adjust, change the law. The only way that can happen is if the legislature acts on this through piece of legislation.
Any other questions on point two? So we went over 3, and then 4th was to direct DOC to add behavioral health and substance use screenings to their initial assessment of the client. That way they can be more responsive as a result of identifying the needs. But I'm not aware of what the current process is. I'm assuming that it doesn't go that in depth for their screening. 5 is to direct the relevant AHS agencies to develop a streamlined method for referring pretrial supervision defendants to behavioral services. So increasing coordination and again, response time essentially to get people the help they need when they need it. And then 6 is to focus the use and resources of the program on individuals who pose the greatest public safety threats. Again, the ultimate goal from their perspective should be ensuring people are safe, which means focusing on the eligibility and deployment of resources for those highest risk folks. Specifically referencing those with domestic violence related charges. And then
Yeah, the note that I have on this, that David Demore said when he testified to us back at the beginning of the summer, 5 dockets or more, he said, is not a basis for public safety. They're a nuisance, but it's not a basis of risk in public safety. That's why they're looking more at the highest risk of doing harm to themselves or others versus the number of dockets. So you could have one case, one docket, but it's a high risk.
Right.
And then it wouldn't trigger pretrial supervision.
And if memory serves, when the bill was being discussed a couple of years ago, you know, there was sort of anecdotal evidence that 5 would be a good starting point. But I think there was also recognition that, you know, it wasn't exactly a scientifically based determination.
I think the word guess was used.
You could say that. I did not.
Best guess.
I'm quoting Lake Senator Sears.
Best guess.
And then finally, number 7 was to collect and monitor the data related to these outcomes, which, you know, there isn't necessarily a statutory requirement to do that, but there is robust data collection capability within the department. So how that's being currently leveraged to achieve this point, I don't know, I would defer to the department on. And then that's they give examples about other states, but this is really sort of the bulk of the recommendations.
So a question or maybe this is a clarification for the 5 dockets. We looked at data that Ian Sullivan and Tim Leaders-Dumont gave us, and we looked at how many individuals would be at 5 dockets or 10 dockets or 3 dockets. And we felt for purposes of starting this, that the number of individuals that had 5 or more dockets just kind of made sense as far as not having an overwhelming number and having at least a cutoff. And certainly part of what we expected was that they would look at public safety as well, but they would look at public safety with respect to the 150 or 200 people, whatever it was, as opposed to a larger number. Just so a little more than guesswork, which you know, I'm all for guesswork too, but this time was a little more than that.
So the Council of State Governments, when is their recommendations due to come out?
First.
December 1st. And then the question will be, is there going to be proposal offered to the legislature on their recommends? We don't
I
know.
can't speak to this point. I think actually that the CSG report is not dictated by statute. I think we had, as Ben mentioned, they had some grant funding available to focus on a discrete program like this, and we work with them on that, but it wasn't put forward anything.
Yeah, I just saw a document that referenced December 1st, so I think I projected to.
Yeah.
So does this committee have to give any thought or direction to our policy committees on this? Do you want to? We want to be silent, knowing it's at play right now with the Chittenden pilot project. And how many people Judge Zoney are on this in the Chittenden? Is it two?
I believe she said one, with 4 other referrals.
Yes, I could. 4 other referrals within the Chittenden? Yes. And where are those coming from? Is it coming from the state's attorney? Is it the court?
My understanding was that they came from a special prosecutor.
Martin, do you still have your hand up or is that a legacy hand?
No, it was a new hand. I just wanted to inform you that I do have a bill request in that at least allows the direct filing by the probation officer just to get the ball rolling on that.
I hope that bill comes to my committee.
Do you want to co-sponsor it with me?
No. No, I'm thinking because I kind of make a.
It'd be too late for that, Martin.
Oh, right, I've okayed it for introduction. I forgot.
Yeah.
I just kind of say to myself, I don't really want to put my name as lead sponsor on bills
On
because.
anything associated with me, is that what you're?
No. Being chair of a committee, that kind of carries a little more weight, and I'm just a little more hesitant for that, particularly if the bill will come to my committee.
I
That's
think
why I do it, Alice.
it doesn't seem to give any more weight when I, as a chair, have signed.
I know, right?
Onto the bill. I guess that must be the dean of the house has that extra influence.
No, it's just something personal that I feel more comfortable not doing it, because I don't want many members to feel obligated.
But I'm sure to answer your question, I mean, I would say it's your prerogative if you want to provide some direction to the committees of jurisdiction. I mean, as Rep. Malone said, there is a vehicle in the works.
It's up to the committee. Want to be silent on it, or do you want to weigh in? It's up to you folks.
What exactly, weigh in on exactly?
Any of the recommendations
Oh.
that, or that, we support the pretrial supervision program. And let's do a update to it. Doesn't mean specifically some updates, or we could get into specific updates, or we could be silent on it.
You can also make sure you get a copy of the final report from
We
each
should get a
industry before,
copy. The final
if you'd like to
report.
consider that before making any recommendations.
Yeah, because if it, I mean, I think you would know better, but if the timing works out, there is still the meeting in December.
Right.
That's
You can
You're not
discuss.
gonna be here.
Hold on. It'll be Michelle.
It'll be Michelle. I mean, we could do that. If folks want to talk about it at our December 15th meeting.
I'd rather read that report before I.
So when we get the report, send it to Megan, and then Megan can send it back to us. Jenny?
So I'm just wondering, it's a report with recommendations that committees of jurisdiction will look at regardless. I think our recommendation or our sending a message to committees of jurisdiction would probably be more relevant for some of the work that we've just heard about this morning. That this is ongoing, and there are key areas that committees of jurisdiction should evaluate. I think this report probably stands alone. What committees are receiving this? Is it judiciary or are healthcare committees, health and welfare, human services, also
Well-
receiving the report? Because there is stuff in there on behavioral health and.
Well, since
Mental
there's no statutory requirement, I think it would just go to DOC and then it would just be DOC's opportunity to distribute it to any committees.
CSG.
Well, then my suggestion would be to ask DOC to send it to committees represented on this committee. But beyond that, I'm not ready to endorse or not endorse any specific recommendation.
So we'll schedule for our December meeting of Isaac, you'll be sending the report
Yes,
to
that's-
Megan, so at least we have it here and then we can make a decision. And also for our meeting on December 15th, I don't want to lose what Jenny just said. For us to bring up for discussion, do we want to make a recommendation to the standing committees about the pilot project in Chittenden County? In terms of what issues maybe those standing committees should look at that came to light. One being the MOUD program within DOC came to light. Maybe the pretrial supervision, the other part could be resources for our state's attorney, defense counsel. Concerns about how you roll this out to other counties. Those are some of the items, maybe. Just putting that on the table to see what members are thinking.
The other thing, as far as timing, how this all may play out, if I recall from the Department of State's Attorney's testimony, that they're thinking February would be once all the data is ready, but that's also sort of the
End of
the pilot, right?
Right.
But at that point in February, you'll have a bill, there may be a potential hearing on it already. So any recommendations that are derived from the data that's received could maybe go into that bill.
So just keep that in the back of your minds for our December meeting, just to see if we want to make any recommendations on the pilot project. We don't have to. Just be thinking. Anything else on the pretrial supervision piece? Because that is, that may be tweaked during the session, we don't know. And it plays into the pilot project as well. Anything else? Okay, so we can move on to the post adjudication working group update.
Did you want me to give like a brief overview of Act 180?
It's brief, yeah.
Okay. So Act 180 is what this group was derived from, Act 180 of 2024. So this was a almost 60-page bill that created the pre-charge diversion program. Now, there was an initial concept to also potentially do it on the back end, to have a sort of a standardized reparative program for people that have already been adjudicated to help with pairing them with services, rehabilitation, having more accountability with the victims. But it was realized during the development of, or I guess the progress of the bill in that session, that just to focus on the pre-charge diversion and create a working group for the post-adjudication reparative work. So that's what this report emanated from. And just to give a very brief sort of snippet of what the enabling legislation was that, so this program was to promote uniform access to the appropriate community-based service providers for individuals sentenced to reparative boards or probation pursuant to 13 VSA 7030 A2 and A3. Those are the sentencing alternatives. You can be sentenced to work crew, you can be sentenced to incarceration, you can be sentenced to probation, reparative boards. And they said for those that have to go in front of reparative boards or for probation, let's create a rehabilitation program for them. The working group also needed to study how to establish a stable and reliable funding structure to support the operation of those appropriate community-based service providers. So that's the general goal and objective of the group, and I'll leave it to Judge Zone and Derek Miodovnik from DOC to elaborate on the recommendations and work that was done.
Has that report been submitted to and posted on our webpage?
Yes,
So I looked
just the other day I forwarded it to the committee.
Right, you forwarded to, has it been posted on our webpage?
Yeah,
Okay.
it's under the reports I researched, it's that.
I don't have my iPad, it's being worked on, so. Okay. Anything else for Ben before we transition to Judge Zone and Derek? I'm not even gonna go with your last name from DOC.
So.
You both want to come up?
All right, well, that was my last time in hot seat.
No.
Tough act to follow.
Oh,
Feel relief?
a little bit, yeah.
Good afternoon, Tom Zone, Chief Superior Judge.
Derek Definite Community and Restorative Justice Executive, Department of Corrections.
So we were on the committee and we did submit the report. I think I would characterize it like this. You currently have a reparative probation program. The report makes recommendations on, I would say, fine tuning and adding some factors and other aspects to it that cost you, Representative Squirrel, get ready for this, nothing. It is what has been done as recommendations really take what currently exists. If you do nothing, the program is still there. It just doesn't have some of what I'll call, again, the fine tuning that came from the members of the work group, the input, other stakeholders who we heard from, say what can make this program more robust, work better, and be more uniform throughout the state. Is that accurate?
I think that characterizes it perfectly.
And so what we did was the group came up with, in the first recommendation was to change in the criminal sentencing statute in Title 13, to change some language there because every one of the other sections for sentencing alternatives merely said what we could do, refer, impose, something like that. And yet the one for the reparative board went a little bit in a different direction. And so we thought it should be a consistency there. And the other ones sent you back to Title 28 for Department of Corrections. And so that's what we did. We said, okay, let's take it, let's refer from Title 13 to Title 28, where it should be. And then we looked at recommendation 2 as for one thing that we thought would be appropriate to change was to get rid of civil contempt for child support orders with reparative probation. It never has been used and it's not something that really fits well there. So we recommended getting rid of that. But our big recommendation was to do a new statute. And the new statute basically takes what's currently in existence for the ability of the court and the cases that can be referred. There is no recommendation made to add any category of cases or remove any category of cases. It simply goes forward with the existing policy. It talks about what we can do as far as whether you have to place somebody on probation or not. That's existing. It then goes on to talk about it can be a condition of probation. That's existing. And then in subsection D of the new statute that is recommended, it talks about factors that the court that should be considered when determining whether to have someone do reparative probation. Right now, there are no factors. And so if you think of it in the context of what you just talked about for the pretrial supervision program, if it said we have pretrial supervision and the court can use it for people, and then it had no factors for the court to consider, that's kind of where we are now. And so this gives some factors for the judge and the parties to understand what the court's going to be looking at. Is there an agreement? What's the view of the victim? What's the impact on the community? Is the person willing to participate in the program? Can they meaningfully participate? Do they have the capacity? And that could be whether it's a mental capacity or a physical capacity to do something. And then whether there are any orders in effect between the offender and any victim that may impact that. The other two aspects of the bill that we recommend is to create standardized forms for referral. That came from the CJCs. They felt that was important. And it also would allow the Supreme Court to effectuate procedural rules like we do for other aspects of the criminal justice system. So,
yeah, and I would just underscore that this substantive piece really reflects the collective experience of the providers. And when we say service providers, we're talking about, again, the entities that we often refer to as community justice centers. But these are the granted agencies across the state that are providing the restorative process. and receiving these referrals and increasingly finding different variations of why the referrals don't really align with some necessary criteria for that to be a successful case. And those providers represented 5 different regions of the state and checked back with the remaining directors. So it had the benefit of, I think a consensus on the provider side as far as we understood.
I agree.
So the one thing I'm looking at the report now, and one of your first changes is the referral, like right now it goes to a community reparative board. And you're changing that to program.
The words program and board were used in different contexts, so we tried to have a consistency.
So referring to the program pursuant to Title 28, is there a definition anywhere of the program?
Sort of just for,
Yeah,
yeah, it's in, I think 28 be the same time.
okay.
And if you look at our recommendation 2 has section 910, and that was where we, one of the reason we took the word program and moved it up as opposed to board, because in 910, the word program is the word that's used to have consistency.
And I would also add that the word board has also some other granular definition from a point in time when the Department of Corrections directly appointed those members, and we've intentionally devolved that to be a function of our community partners and the grants. And so program, I think, encompasses the spirit and intent without doubling back to a legislatively defined point in time that does not reflect the evolution of this infrastructure at this point.
So these are recommendations that the working group is proposing. I'm going to ask Martin, is there a drafting request in for this? No? So, well, what would be the next step for this? You looking for sponsors? Is it something that's gonna?
You could make Ben do this or not let him leave.
I don't think that's gonna work.
I mean, certainly it's up to the committee and the members of the General Assembly. If those who have reviewed this feel that it's something they'd like to go forward on, I suspect somebody could put in a drafting request, and we'll certainly provide any testimony and information that may be asked of us.
Because the report goes to House Judiciary, Senate Judiciary,
And
House Corrections and Restitution, so it could be any member of any of those committees may put in a drafting request.
Yeah, and if I'm not mistaken, the language in the working group charge included to file this final report in the form of draft legislation.
I could send the Word version of it if that makes it easier for somebody.
It's not gonna be the, you can forward it to Michelle. Any further, Tucker?
Judge, right now, as we sit here, before even thinking of those recommendations, can a court impose on an individual that they must do something? I'm asking you this question when I think I know the answer. I think you can, but I'm not sure. Can you say to somebody, part of the conditions here is you have to take part in mental health counseling?
Yes, but there's a but though.
Okay.
The but is that what the court orders as part of the sentence has to be related to the offense conduct and the correctional needs. It can't be, if there's no evidence, for instance, of someone needing mental health counseling or anything whatsoever indicating that, the Supreme Court has said that you need to draw a nexus between the conditions that you were imposing for the probation, for instance, in the sentence, and the conduct that is underlying the sentence.
Yeah. So people in here with 5 or more, there's probably a good reason to say that you must take part in some kind of counseling if it's a mental health problem.
I think oftentimes with individuals with a number of cases, that the attorneys are looking for programs that would involve mental health counseling.
Okay. Now, in the bill, I mean, in the recommendations, it says, if the person agrees to do it.
One of the reasons for that is that the benefit of the reparative program is that someone can give back and they can have closure, if you will, with the victim, and the reparative board has the ability to craft something that's going to work. If you have someone that says, I absolutely have no desire to do any of this and I'm not going to do it,
Yeah.
The reparative boards will generally send it back to you. And so if you know that right up front, it's helpful to know. Does that mean you have to absolutely have someone agree to do it? No, it's a factor that the court would consider in determining whether it should impose this.
Okay.
Other questions?
This has been a question that I've had for some time, and it might not be part of the working group's sort of MIT, but when they fail the reparative board program, they're referred to further sentencing. Did the group discuss what further sentencing meant?
Yes. It's not part of our report. We actually did have that discussion.
Because it's been up to and including the max.
And that was part of the discussion. And I believe I pointed out during our meetings that there actually were forms that I had utilized in one of my assignments that were very clear about that point, that you're going to go to reparative, but if you don't successfully complete it, you come back for sentencing up to the statutory maximum provided for the crime of conviction.
So you put the onus back on the person. It's up to them to decide if they really want to work through with a reparative program or not. And knowing the ramifications if they don't, they're subject to be sentenced.
And I would echo what Derek said, and that is the individuals who are on this committee, a great cross-section from across the state, and they reached out to their colleagues. And it was very impressive to see their intent. When you talk about it's up to the individual, it's up to the individual. And they're working with people who want those participating to succeed. So it was a very impressive endeavor from my perspective to work with this work group and these individuals.
Anything else? Thank you.
Thank you. Have a great day.
Yes, thank you.
Thank you.
The day with us.
Thank you, sir.
Very much,
We're
Nora.
going to shift gears. It was concerned about, we've got secure facilities in terms of we've got moving pieces in terms of secure facilities. We all know about correctional facilities trying to okay. We've been trying to cite some secure facilities, number one, which kind of brought this issue up a little bit. And then some members have wanted more of an overview in terms of where we're headed, particularly in the mental health system, in terms of not just any facilities, but also programming for that. So this is what we are going to transition to. We have the Secretary of the Agency of Human Services, Secretary Samuelson, the Commissioner of Mental Health, and the Interim Commissioner of DOC. Plans percolating along. It might be helpful if all three could come up at the same time. And we can start with the secretary and then go with the two commissioners to weigh in as appropriate. Broad discussion, for the update, but you may be able to share with us some thinking going forward, or you may not sure. So welcome, the three of you, and if you could introduce yourself for the record. And two of you have a hard stop at 3. Okay. And we'll keep the Commissioner of Corrections a little later.
I have a hard stop at 2:16.
That's a hard,
Too bad.
not a stop.
It's not gonna be that bad. Welcome.
Sure, thank you. For the record, I'm Jenny Samuelson. I'm the Secretary for the Agency of Human Services, and it's a privilege to be here with members of my executive team this afternoon. Thank you for having us.
Hi there, for the record, Emily Hawes, Commissioner for the Department of Mental Health.
I'm John Murad, the interim commissioner for the Vermont Department of Corrections.
So our goal today is to give a brief overview of the system of mental health care in the state of Vermont. It's important for everyone to recognize that mental health is an agency-wide issue. And while we have the Department of Health, this is a topic that our executive leadership team spends significant amount of time because it touches each one of our departments, and we need to have an agency-wide plan. I will, after we have an opportunity to go through the system of mental health care, our goal is to introduce some areas that we see opportunities and gaps. And my hope is that we can enter into conversation and dialogue therein. As I said, I'm joined here by two of our executive team members because, as I said, this is an agency-wide issue. And so the Commissioner of Mental Health and the Commissioner of Department of Corrections can help fill in some of the gaps in our conversation today. So on that, Chair, if it's okay, I'll turn it over to the Commissioner.
Great, thank you. We typically like to start out with this slide, which is a visual representation of the services, facilities, and programs available throughout the mental health system of care. And before I talk through these different layers, I just also wanted to highlight that we'll talk soon with Commissioner Murad about the Department of Corrections, but it is our goal that our community members, wherever they are, whether they're incarcerated or in a nursing facility, that they have access to all of the levels of care and services provided by the Department of Mental Health and our contractors. So I'll start with our foundation, which is our community mental health system. So this is the largest block at the bottom, and those are the services that are provided out in our communities, for the most part, provided by our designated agency system. You'll see we also list in there group homes for both youth and adult. We also have shelter plus care vouchers, which are housing vouchers that include about 20 hours of additional mental health supports for folks. The next, Are those HUD? it is a collaboration with HUD. Okay. Sorry, just.
It's fine.
The next layer up are our crisis supports and response. The Department of Mental Health has been focusing on this particular level of services intensely for the past couple of sessions. This is where you find our programs such as 988, our mental health urgent cares, as well as our enhanced mobile crisis response. And then other types of stabilization for folks like our youth hospital diversion program and our children's crisis stabilization programs. The next layer up is our intensive residential and treatment programs. This is also across the age span. We have our youth residential programs, our adult intensive recovery residential. We also have a peer-run residential program. And then coming online, hopefully sooner rather than later, is the work that the legislature did around the psychiatric rehab facility for youth. And that's, I think, a PRTF. That's around 12 beds for youth.
And where is that?
It will be at the Brattleboro retreat. And that's a step down from a hospital level of care, but still requires 24-hour nursing. The next step up is the River Valley Therapeutic Residence. River Valley is a 16-bed residence for adults who are under the care and custody of DMH. And the next layer up, which is your most intense layer, is the inpatient hospitalization. And we have inpatient hospitalization across the age span, children, adults. We have general adult units at UVMMC, Brattleboro Retreat, and Rutland, as well as the Wyndham Center. And then we also have what's referred to as a level 1 unit, which are units that are specifically designed with a staffing model to serve individuals who are at the highest acuity and who may need, say, court-ordered medications.
So are all the inpatient hospitalization, they're not all at level 1 acuity, or?
They are not. We have currently 25 beds at the Vermont Psychiatric Care Hospital, 20 at the Brattleboro Retreat, and 6 at Rutland Regional.
20 adult.
Adult. There are no level 1 beds for youth. Level 1 was essentially developed after Tropical Storm Irene. And so that's how we designated, really from a payment perspective, what used to be services provided in the out-of-state hospital setting.
We're all 25 beds at the psychiatric hospital being used.
They are not. They're staffed for 21. And they have 16 people admitted there right now with 1 referral pending.
Part of the issue is staffing.
That is the issue, staffing, yes.
So on the River Valley, that was initially built as really a step down from our state hospital. We did not include emergency and voluntary procedures.
Initially, that's correct.
Initially, we did not include that. So that has shifted with the intent, as it was going through the legislative process in 24, not in 25, for forensic folks. And in order to do the EIPs in that facility, we had to do renovations.
Yes.
In that facility, because it was not built to accommodate the EIPs. So there was a request from the administration during the session of
EIP.
Emergency and voluntary.
Emergency. I got that. I got it, but I wasn't getting the E. Okay.
It's typically
Yeah.
seclusion and restraint.
Yes, seclusion and possibly separate.
Is that always done on an emergency basis?
Seclusion and restraint?
Yeah.
Yes. Yeah. It is against a CMS regulation to pre-plan a seclusion or restraint.
So the building was not built to accommodate that. So in the session of 24, there was a request for a forensic. And folks were thinking, well, we have some beds in secure residential. Let's allow those folks to go into the secure residential in Middlesex, but we have to allow EIPs to be in play, which then meant renovations. So are the renovations done at this point?
It is not done. They should be done this spring, I believe. There were a couple of delays, but work has started.
And how many beds would be available for the EIPs?
There's no bed associated with a seclusion and restraint suite.
So it could be for all 16
It
beds?
is absolutely for all. We do not differentiate in DMH facilities who is involved in the criminal justice system and who is not. It is purely treatment appropriate.
So if you determine that they were forensic unit or forensic folks, would you receive Medicaid reimbursement?
If we operated River Valley or any of our hospitals as a forensic unit, we would not receive Medicaid reimbursement. Medicaid does not reimburse treatment for individuals who are forensic.
And for individuals that are forensic, is that for folks who are pre who have not been adjudicated as well as for folks who have been adjudicated?
Oh, that's a good question. I know that Karen Barber, our general counsel, is joining us today. So I will kick it over to her to differentiate if she doesn't mind.
As we've talked in the past, little F, big F.
Oh, yeah. And this is Karen's favorite topic is little f and big F. So Karen, if you're able to answer the question on the adjudication.
Sure. Good morning. For the record, Karen Barber, General Counsel for the Department of Mental Health. So the way, so we use forensic in a couple different ways, which is why I think it gets confusing. The CMS definition that we use for forensic is different than I think maybe the way you're looking at it. And so when we have folks coming into our system at either a hospital or at River Valley, they would probably be forensic in the way you're thinking of them, but not necessarily the way CMS looks at them. So when we are looking at them, if they meet clinical care criteria, meaning they are in our facilities, not because there was some criminal court order in terms of like a way to securely hold them, but versus they need to come into our system because they meet clinical need, then they are not forensic in terms of how CMS is looking at them, meaning we can use Medicaid funds to pay for them. So everyone in our hospitals or at River Valley that also have connections to the criminal justice system are not considered forensic for CMS purposes because they are receiving care at our facilities, and they only can enter our facilities if they meet that clinical criteria. So everyone is there because their mental health needs are acute enough that they need that type of setting.
And Karen, is it accurate to say that we would have folks in our facilities who are, whose charges are pending, but also whose charges have been resolved by either dismissal or they have stipulated to an order of hospitalization or an order of non-hospitalization?
Absolutely. We do have folks in our system that also have pending involvement in the criminal justice system, but they are in our facilities because of their clinical needs.
Yeah, so I want to reinforce that anyone who is currently at the psychiatric hospital or who is at River Valley is there because they have a clinical mental health need. And I think one of the gaps that you'll hear us talk about later on is that when folks think about forensics, they don't just think about mental health. But for our psychiatric facility, for our two psychiatric facilities, both residential and the inpatient hospital, individuals who are there and receiving care there are there because because their primary diagnosis is mental health.
Yes, thank you.
So if there's someone who is incarcerated, be it a detainee or a sentenced folks, and their mental health acuity has come up to level 1, DOC can send them to our state hospital.
Correct.
For stabilization.
That's correct.
Do you get Medicaid reimbursement for that?
They're there for a clinical diagnostic reason. I believe we do.
And then once they're stabilized, my understanding is
come back.
Corrections.
That's actually, let me think that through a little bit because we are in the middle. I don't want to get too far into the
They're not
weeds and we
enrolled
can
in
come
that.
back.
Can we double check it? Because
Yeah.
once an individual enters into corrections,
They lose Medicaid.
they're unenrolled in Medicaid. And so if they are not currently enrolled in Medicaid, they would not get Medicaid reimbursement at the hospital.
Would there ever be a situation now that we have EIPs at the secure residential River Valley, would there ever be a situation where someone who is in a DOC facility could end up at River Valley?
If there was a clinical need for them to be served at River Valley, it's only about what that individual's clinical need is for services, not necessarily that they are at the Department of Corrections in the facility or out in the community. It's really the package of services provided at River Valley.
Emily, is it fair to say that what you started with at the beginning was we want to make sure that within DOC, in the Department of Corrections, that individuals have the full continuum of care? And there are some gaps there, and it's one of the things that we're trying to fill right now. But for those who need a residential level of care or who need an inpatient hospital level of care for mental health, they are actively receiving treatment at both River Valley and the Vermont Psychiatric Hospital now. And so that patient flow already happens. Right now, DOC is not set up to provide those two levels of care. So if someone hits those levels of care, they move over to the Department of Mental Health for treatment.
Yes, and it's not uncommon for folks to access care across the system. All of the hospitals have the ability to take somebody from the Department of Corrections. And so if somebody is voluntary, it can happen that way. It can also happen on an involuntary status as well.
So you have another page.
So
Thank you.
Any other elements on the system of care that you'd like to go through?
Not if there's no questions at this time.
I can't see anyone on Zoom, so if anyone has questions, raise your hand, speak up.
In other words, you're prepared for a different question, but we didn't ask it.
Yeah.
I gotta figure out what it was.
Yes. Would you like for me to go through the system gaps and opportunities? Okay.
Yeah. So AHS has been actively working with internal and external partners to strengthen our system and care and trying to ensure that the processes promote the well-being of clients. I do want to say, I want to give props to the Department for Mental Health over the last few years. They have filled significant gaps in the crisis system of care with mobile crisis, 988, the mental health urgent cares, and have really moved forward in making sure that we do co-occurring care for substance use at our designated agencies through the CCHC work. Likewise, the Department of Health has also made sure that mental health care is provided through our hubs. That said, we do still see some significant gaps in the system that are worth pointing out to this committee. And I'll go through each one of these in more detail. But really, we would look, and I won't go into great depth. I think what folks will find is that we are working on an omnibus bill that will potentially be introduced in the session. So I will touch on each of these at the high wave tops. But we really are looking at gaps in our competency evaluation system. We would also want to connect, we have a connection that we now see, particularly for those who are justice involved, who do not need to be incarcerated, opportunity for pretrial supervision, and I'll go through why. And then we would look at expanding services in corrections. What you heard me say before is that we have a system right now. We've been focused a lot in our conversations about substance use, but in the mental health system of care, we want to make sure that an individual who is in corrections can get the same level of care inside of corrections that they would get in the community. It's one of the reasons why we use our inpatient facilities for mental health, but we also are looking to reinforce treatment for both substance use and mental health and corrections. And then Chair, you mentioned previously a gap that we've been talking about for folks for years, which is really that concept of a forensic facility. We did fill the gap by allowing some of those services to be able to be provided at River Valley. But I think that there is broader understanding that if someone does not reach the mental health level of care at River Valley or at the hospital because of other conditions, there is a gap in that system of care. And connected with that, there's a need for competency restoration. So together, these efforts really we would look at for closing each of these gaps are really looking to enhance the system of care to ensure that we meet the needs of our clients and the health and safety of our communities. I want to highlight again that we're working on an omnibus bill. And so I'm going to touch on each one of these in detail, but at a high level. So for competency evaluation, Vermont frequently seeks competency determinations early and for a wide range of crimes in criminal cases, often before considering other types of diversion opportunities or other treatment-focused alternatives. This becomes challenging. It is typically best practice that we have seen in many other states where competency evaluation is primarily for individuals who have the highest level of crimes and not done for misdemeanors. In addition to that, the sequence that we're talking about creates challenges, including impacts on our public safety. It limits accountability. It provides additional strain on the system and reduces effectiveness in connecting individuals to treatment because we're not looking at those diversion-oriented approaches. When a person is found non-competent, it doesn't mean it and does not meet the criteria for involuntary care that we were talking about before, either for inpatient or for residential. It puts significant strain on the system, and the courts have limited authority for their requirements for requiring someone for treatment. Orders of non-hospitalization, I think, are important for us to have some conversations in it. They're for involuntary treatment only, and because of that, the laws, which we have not revisited in over 40 years, have strict legal clinical thresholds in them. It's not DMH who determines those clinical thresholds. It really is the law. And individuals who do not meet that level of care, they're not able to admit them in an involuntary status. I think that there's a misunderstanding in many cases there. And it has to be for mental health. It can't be for substance use. It can't be for someone who has a traumatic brain injury or has another type of care that they need and are determined to be incompetent. Individuals who we know engage in diversion type activities, who continue with the court, have broader incentives to continue to look in treatment. That could be conditions of release, or the incentive could be that their charges are dismissed after they've gone through the treatment process. I also want to note that treatment often is a major component of competency. And so the order that we currently have it in now, where we do competency evaluation before treatment, particularly, for example, at the psychiatric hospital, when they have to do it within 28 days, an individual may not have been able to go all the way through their course of treatment. And each one of these competency evaluations ranges anywhere from $4,000 to $8,000. And so we're not actually allowing the treatment to determine competency. So they're misordered. We also would like to explore alternatives before pursuing competency evaluation, including increasing the level of engagement in treatment connected with something like pretrial supervision. So again, competency evaluation, a few things. Typically in other places, it's not done for misdemeanors. It's typically done after a course of treatment. And we know that the incentives that you compare with it in terms of conditions of release, if you don't discharge the charges, or if you include them in pretrial supervision, allow greater incentives.
Secretary, would it be okay if I gave a little context for how many evaluations are ordered in a year? So far in 2025, the state or there has been 743 evaluations ordered. And so when you think about the amount of people that are going through our court systems and the number of our population here, that's almost 1,000 before we're even finished with this year. So, and that's about right on track. We usually hover around 800 to 1,000 competency evaluations a year.
Are those new within that 800 to 1,000? Are those unique individuals?
No.
So can you run through the duplication that often
Sure.
happens and also the percentage that we see where they're misdemeanors?
Sure. So somebody may come in and be arraigned on an initial charge, and then a competency evaluation is ordered. And that may happen out in the community. It may happen while they are in the hospital. Oftentimes, And it also could be a misdemeanor or a felony charge. If an individual then picks up more charges before the original charge gets resolved, they order another competency evaluation for additional charges. And so I think one of individual had 15 different competency evaluations. And when we talk a little bit about opportunities for diversion, anytime you prolong someone's court case or prolong someone's engagement with the criminal justice system, you may be negatively impacting their ability to connect with treatment. And so we want folks to get connected with treatment as soon as possible. From a misdemeanor felony perspective, from 2019 to 2024, there were 4,600 and change competency evaluations, and half of those were people who ended up being competent, and though they were misdemeanor charges. And so those folks were screened, were evaluated, were able to participate in their court process. And they were charged with a misdemeanor. And so there's a lot of opportunity where we could be engaging folks a lot sooner.
So just on first blush, and I spent a lot of time thinking about this, but it seems odd to do a competency evaluation in misdemeanor cases to me.
Yep. And before you've done treatment.
Right.
A lot of states approach it from a felony and serious crime perspective.
Yeah. And so I guess what I'm trying to think about, is there a lower level assessment that could be done in a misdemeanor? I can foresee, let's put it this way, that public defenders and the legal aid are going to have a lot of problems with this. So I'm just trying also to think about what potential solutions there might be and whether or not there's I know competency evaluations are expensive and, can only be done by certain individuals, and whether there is I guess I would say a lower level assessment. If for whatever reason, it ends up continuing to be needed for misdemeanors. But I'd say on first blush, it seems misdemeanors, unless there's 20 of them or whatever. In which case, that was this morning's testimony.
I think about this stuff. This is what keeps me up at night, right? And also, I know Karen's been hovering around the big F and the little f for a long time. And when the competency is really a legal term and is a legal process. But what folks really think about is connecting somebody and having them being assessed for clinical care. How can we support them getting engaged with treatment to manage their symptoms of mental illness? And I think that evaluation could happen in court. I know that it happens sometimes as somebody goes through the diversion process or the restorative justice process or pretrial supervision process. It's really trying to get somebody connected to the right treatment that they need. And once competency comes into question, oftentimes that connection to treatment can get delayed, especially from an outpatient perspective.
Yeah, I can see that.
Karen, did I answer that appropriately from your lens?
Yes, you did a great job.
Okay, thank you.
And so I think that goes really well into the concept of pretrial supervision. So, as we're talking about opportunities for an individual to go through treatment before we would do a competency evaluation, and they are in the community, pretrial the courts decide whether they're in the community or whether they're incarcerated. But when we hook that up with pretrial supervision, it supports eligible individuals in getting that evidence-based treatment. It promotes compliance with court conditions as they go into the community, and improve attendance at hearings, and it reduces recidivism. And we've seen that in other states, where what they've done is take and do from the court to pretrial supervision. Pretrial supervision has the conditions of release, including treatment in our system, and the opportunity, particularly if it's misdemeanor charges, to have them dropped if they're successful in treatment. It provides a graduated level supervision, ranging from automatic reminders and telephonic check-ins to in-person meetings and electronic monitoring. So it gives us an opportunity if someone isn't engaging in treatment in the way that they had agreed to with the court, to catch it early and to go back into the process. Right now, for example, with an order of non-hospitalization, without having that pretrial supervision, without having that connection to the charges, the communication back to the court can be 3 or 4 months if someone isn't engaged in treatment, and only after they're exhibiting significant symptoms. So we've launched pilot programs in Orleans and Essex County with the goal of reducing the backlog statewide. But what I will say is that there are some critical pieces in the pretrial supervision process that aren't working right now. And so that's one of the things that we will come back to have a conversation with, is really what can we do to make pretrial supervision more successful and more supportive of treatment.
We have a question here, Bob.
Yes, thank you. I just wanted to back up to the competency evaluations once again. 700 or so, that sounds like a lot of evaluations. Are these court-ordered evaluations? I have several questions there. These court-ordered evaluations?
Yes.
Does the Department of Mental Health have the opportunity to say no?
No.
Are these all done by in-state psychiatrists? And wasn't there, then we push you a bill that you can use out-of-state psychologists?
Most are done. Yeah, most are done via telehealth.
And did that drive the cost up in-state?
Not necessarily. And we do have one evaluator who's in state. I would say that all costs of healthcare have risen, and this is a healthcare type of service. The evaluators are typically physicians.
So I guess I'll narrow it down to a couple of questions. If you average 800 a year, as you had stated earlier, roughly what's the cost of that? And if a court orders a competency evaluation and one party or the other doesn't like that, can they ask for one? And if so, do you have the right to turn them down, like a state's attorney's office or the defendant general's office?
Yeah, and I'll have Karen answer this question specifically around the number of orders, because we've done some legislative work around the number of evaluations that can be ordered. Karen, go ahead.
Sure. To answer your second question, maybe. So we are responsible for doing neutral evaluations. So those are the first evaluations. If a state's attorney or defender general wishes to get their own, they are free to do so. We don't pay for those, and we wouldn't necessarily know about those, so those don't factor into our numbers. As to the other question, there was a change in legislation a couple years ago, because it used to be that we were getting multiple evaluation requests, and we were really getting concerned about that, because unless there had been a clinical change, we knew that there probably wouldn't be an outcome change in whether someone was found competent. So legislation did change the language to say that an additional evaluation could not be requested of DMH unless there was a clinical change. So we have seen some of those numbers go down, although judges interpret that differently in terms of what sort of clinical change they want to see before they'll order a second evaluation. But if we get an order from a court that says you must do an evaluation, we don't have grounds to say we don't think that it's appropriate at this time. We just have to do the evaluation.
Yeah, DMH doesn't have party status for criminal cases. And so the court will order the evaluation, and we essentially operate as an administrative pathway to getting the evaluation set up.
So you're simply contracting. So you're just a pass-through.
Correct.
The court orders it, goes to DMH. DMH has a contractor who does that on the state's behalf.
And so just to follow up, the last part of it was just ballpark. What are the costs?
Sure.
Approximately.
Sure. I know, because I get to sign off on all of the invoices. Some are as low as like $3,600, and some can push over $8,000 and change, depending on how much time the evaluator needs to do a thorough evaluation.
So the total cost, ballpark?
2 million. That's a lot of math on the spot. I don't have that.
There's about 1,000 of them that are done every single year.
Thank you, Jen.
And they
Secretary.
range anywhere from $4,000 to $8,000. So you're talking north of, or getting close to half or $1 million.
Yeah, I think this last year was $1.5 million.
Yeah.
So Alice, I have my hand raised.
Yeah. Yeah, I can't see, so go ahead.
No, you don't. I've just remembered that. So yeah, this is a terrific conversation, and I know I've talked with Commissioner Hawes about the competency evaluation process and having it post-treatment. I think that it on its face sounds very reasonable and probably something to be done. I think it's important for all of us sitting here to understand that competency evaluation is done to determine one's sort of reasonable understanding of how a trial might go forward and what situation they're in. It's not about the individual's mental health status at the time the crime was committed, regardless of what it was. So there's a distinct difference there. My question is, once competency is determined, now suppose someone's competency is being determined not because they're in a criminal situation, but simply to understand, do they understand a specific kind of situation? Do we ordinarily do that once, or do we allow for recurrent and ongoing evaluations to take place? Why does this become such, why does this continue time after time after time?
I'm trying to think about how to answer your question, Senator, because there's not competency evaluations unless there's a crime being considered.
It's only yeah, you're right. It's only a legal
And so for
determination.
anybody else who is receiving care and treatment, whether, let's say they're involuntary and ordered to a hospital, those are managed and through the family court. And then the treatment team is working with the family court to determine somebody's progress through treatment.
So I think, Senator, you're right in defining what competency is and what it isn't. Competency is simply whether someone is able to participate in their own defense. So it is, can they engage in the legal system? And so I think that it's important for us to distinguish between competency evaluation and competency restoration so that folks have a clear understanding of what we're talking about. So Vermont lacks a competency restoration system, and competency restoration is typically a combination of both mental health treatment and support and education so that individuals can grasp and understand what's happening in the legal system. Because again, a competency restoration is not about someone's mental health and well-being. It is about their ability to understand the court system.
And someone may be found incompetent for a variety of reasons, not necessarily just their symptoms of mental illness. Like the secretary mentioned earlier, it could be an individual with dementia or a traumatic brain injury or substance use.
And so I think that there's a misnomer sometimes when folks someone's competency hasn't been determined, they have been determined to be incompetent, that they will immediately be remanded to, say, the Department for Mental Health and in one of the two facilities that we talked about previously. And that's not the case. In particular, I think that fundamentally becomes a really large discussion when we're talking about the overlap between mental health and substance use. Because when we talk about for example, a traumatic brain injury, a TBI, everyone assumes someone was in a car accident or something else. What we are seeing more and more in our communities are individuals who may have had an injury to their brain because of their substance use and long-term substance use, hypoxia from an overdose, or damage to the brain in another way. And so I think more recently, this has become a larger and larger conversation as communities are looking at individuals who are currently actively in substance use. They may be in substance use psychosis. We're able to stabilize their mental health. And then they ask, well, why are they still not competent? And it's because of something completely other than their mental health status.
So if someone is deemed incompetent to stand trial, where are they housed now?
That depends. That depends. If somebody has had a competency evaluation and a court has ruled on that, and they meet hospital level of care, they're going to be in a hospital level of care.
So that could be at our state hospital.
It could also be at the Brattleboro Retreat.
Sorry, I want to say they meet the hospital level of care for mental health.
Oh, yes.
So a lot of
Sorry.
time folks are thinking, well, a TBI, no, it's mental health level only.
So if it's not mental health and they're incompetent to stand trial.
If it's a developmental disability, then we have Act 248, and they're remanded to the care and custody of the Commissioner for the Department for Aging and Independent Living. They are typically cared for in a community and in a community setting. That can at times mean a hardware secured house or a staff secured house in the community. So those two populations have an infrastructure around them. If someone's incompetent, they also could be in an order of non-hospitalization through the Department of Mental Health and receiving treatment in a community if they are stable. Those two populations we have an option for. With the other populations that we've talked about today, if someone has been determined to be incompetent because of dementia or incompetent related to substance use or traumatic brain injury, there is a lack of structure. They are released to the community.
So is that the population you're looking to find a facility to place them in?
So I think you've jumped right. For us, a forensic facility allows us to have a treatment for those individuals who are determined to either be incompetent or insane at the time of a crime. And it would need to be a violent crime. There is an opportunity, most other states have a forensic facility if an individual is not able to live in the community safely. And the court would make that determination and would remand someone to a forensic facility. That is currently a gap in our system of care. With competency restoration, which an individual could go through a competency restoration program in a forensic facility or in the community. And then we could keep working towards competency so that they wouldn't continuously be institutionalized, but we lack the facility for that population.
So they would not be housed at the River Valley?
They would not.
Because it's not mental health.
It is not mental health.
Would they be housed in a correctional facility?
If they are determined, I would turn this over to Karen. But if someone is determined to be incompetent or insane, then their charges right now are typically dismissed because we don't have a competency restoration process. If we had a competency restoration process, a court could choose to keep those charges intact. They could be working towards competency, and corrections could be an opportunity for them. Right now, we don't have a competency restoration program. Charges are dismissed. And if charges are dismissed, they're released.
So I just wanted to finish my thought from previous, and that was about the competency restoration. We've had this discussion in our committee, everything that we're currently talking about here. And we've did ask for recommendations regarding competency restoration. I know that other states have programs that are exceedingly expensive. And I don't know whether we're going to get additional recommendations from Commissioner or Secretary about a restoration program, or even if it's possible in our state. So, and understanding the distinction between IDD and mental health folks is also important. So there's a lot mixed up in this discussion.
Yeah, it's 3:00, but competency restoration program will be done within the forensic facility, who would be responsible for the competency restoration program? Is it DMH, is it DAL, is it DOC?
Right now, the state of Vermont doesn't have a competency restoration program. I think you will see it, it does not. And in many other states, it is housed, could be housed within a correctional facility. Again, these are 4 areas. I want to go back as we close out. These are 4 areas: competency evaluation, pretrial supervision, expanding treatment in corrections to make sure we've got the community level of care there. Forensic facility and competency restoration are all things that we think are gaps that need legislation to address. And I can't go deep into what our current proposals are, but the administration would like to work with the legislature over this next session to address these gaps.
No, just a
little bit, just
not a big issue.
Sarah, I
We
appreciate
haven't talked about DOC, but DOC is kind of in the center of some of this, is my thinking. I may be off base, but I think DOC is kind of in the center of some of this.
DOC is absolutely potentially at the center of many of these solutions. They provide secure facilities, and they have programming that they can offer to support some of these populations.
And their budget's going to be under stress. It's the only place in the agency of human services that is general fund dollars. So,
on that note, Chair, thank you for having us. Any other questions? I think you will find that this is going to be a tough budget year all the way around.
So I do have some questions for DOC that's not good. Yes. And I don't want to blindside the commissioner, but it's something that's percolating.
If it may, Commissioner Haas has a child at home.
Thank you. He's already called, but I think that's just because it's new. Because he can. Thank you.
The 15th of December is the next meeting.
That place and time.
Yes. So my question for the commissioner, and I know I'm putting you on the spot on this, I apologize for this, but there's a lot of concern, at least down in my area. I'm sure some folks have heard about the overcrowding in our facilities. And some of the release valves that we've used in the past have been to increase the number of folks going out of state for our Mississippi contract. I know that there was a bus that went down with 28 more folks a week or 2 ago. There was rumors going around there's going to be more transports out of state. Just think the committee here needs to be aware of that. Some of our colleagues are upset about this. There's also concern that the folks who are going down are folks who are involved in some recovery programs, some peer-to-peer honor, so the honor unit. And the feeling is that people who are really doing well are the ones who are being pulled out and are good role models for other folks who are incarcerated in their units or in the facility. Also the concern with the women's facility, the numbers growing there, that maybe they need to be moved. Maybe not out of state, but if they're moved to another facility, that will put more pressure on moving folks out of state. So I know I'm putting you on the hot spot. I didn't mean to, but this is percolating out there. So I think this committee just needs to have a little bit of an update on it.
Sure. So yes, we did send a bus down 2 weeks ago. I directed that be done. It was the first large transport that we had done since prior to the pandemic. And that was directed owing to capacity issues. I had also anticipated going down myself to check on the status of that transport and that trip, and was prevented by our plane situations during the shutdown. And so a group of folks and I were unable to get down. The good news is that the person in charge of our out-of-state unit had chosen to drive, so he was able to be there and check on folks' status, but I deeply regret that I was not able to. I'd actually been very much looking forward to that trip. And also to hearing what I believe to be inevitable complaints from some of the folks that we had sent. There can be upsides to being in the Tallahatchie facility in Mississippi. Among those are the fact that there are no detainees. Detainees, new people coming into a facility can create sort of changes in the power dynamics, as it were, that are there. And as a result, at times, the facility at Tallahatchie can feel more stable for those who are there. We currently have just over 150 people there now after having hovered at 120 for the better part of the last couple of years. We do not have any intention of going much higher than that, primarily owing to where we are with the budget. As the secretary stated, it is going to be a challenging budget year for us all. We are allowed to, by contract, send it down more, but we do have to find money for those.
What's our contract, 300?
I believe it is 180. Am I?
No, it was around 300, the total contract.
Yeah, and then there's a difference with the budgeted amount.
There's a budgeted amount that we do, and then.
They would be willing to take as many as 3. That's not going to happen. I don't believe that we would have as many as 3 to send down under our current parameters. In fact, I'm quite confident we could not send that many down under our current parameters. We had to adjust parameters a little bit in order to get the number that we did get. Those parameters are dictated by the length of sentence that the incarcerated person has, the presence or lack thereof of imminent court dates, the physical and medical health of the individual. It is not dictated by whatever the underlying crime is and why the person is in our custody. And it is not dictated right now by programming, ultimately. And so, yes, there are individuals who were involved in certain kinds of programming who were a part of that cohort. The hope that we have is that we will be able to take some of the programming that involves the individuals themselves and expand it to the facility in Mississippi. For example, Open Ears is a program you mentioned. It's essentially a peer program for peer-to-peer counseling, essentially, for people who are incarcerated. Having Open Ears coaches there means that perhaps we can actually expand the program to that facility where it does not currently exist. We are exploring how to ensure that people's educational programming can be continued remotely. And that would go for both our CCV programs and our high school, et cetera, programs. But you're right. There is a tragic kind of catch-22 in that the very people who are at times the most stable members of our carceral communities inside our Vermont facilities, people who are there for a long time, people who have acclimated to the institution and are performing well, are also ideal candidates for this kind of transport. That is a catch-22. The answer to that, because we exist in a world where the numbers of people being sent to us are completely outside the control of the Department of Corrections. The numbers of people being sent to us are a function of the courts and a function of of ultimately individuals' behavior. If we could get people to stop committing crimes, we would have need for fewer beds. But as it is, we have a lot of people that are committing crimes and creating public disorder. We have communities that are crying out for accountability, that are very concerned with how things have gone over the past several years, owing to a myriad of various factors. But nevertheless, they are asking right now for there to be more accountability. That means coming to us. We've talked before about the degree to which our detention populations have risen tremendously. 54% we've seen a 54% increase in male detentions over the last 4 years and 104% increase in female detentions over the past 4 years. None of those individuals can go out of state. So we are working on this. We are facing a situation where we have fewer facilities than once upon we did. We don't have as many people sometimes point to the high point well, high point numerically. I don't think it's a high point with regard to where we want to be as a community or a state, but the high point numerically for people in custody of more than a decade ago. And that was with many more facilities. There was a recent article about this in 7 Days, which pointed out where we are and then talked about the 6 facilities. And one little twinge I had reading that was like, well, it wasn't 6 at the time. It was more at the time of that high number. We desperately need a new facility, as you mentioned, Madam Chair, in to replace the one in South Burlington. We also need to contemplate what happens if we get over capacity there. Right now, we are over capacity in general population by quite a bit for general population, both among women and among men. General population is not all of our beds, of course, right? Any given facility has beds in its infirmary. It has beds in special housing, and those count towards the total, but we don't want to, we can't put regular people in infirmary beds, or we will not have them available to be used as infirmary beds. So instead, our general population is the beds that ultimately get oversubscribed, as it were, again and again and again. And those numbers are quite large. I don't have the piece of paper in front of me, but Haley just prepared some of this data for me today with regard to general population. I believe general population is somewhere on the order of
150%.
150 for men.
130% for women.
Thank you, Isaac, very much. 150% for men, 130% for women, over capacity for general population. And now that affects, now we are not over capacity as far as our total number of available beds throughout the system and the total number of people who are currently incarcerated throughout the system.
It's the general.
But it's the general pop. And I want to clarify that, because I don't want it to seem like we're saying we're over capacity totally, we're not. But the fact of the matter is that any facility doesn't want to be at its absolute capacity, because that does mean that every single infirmary bed is covered, every single special housing bed is covered, every short-term detention bed is covered, intake rooms, cells are covered. We want general population to be at about 80% of capacity is really where the best practices across the profession are, because that gives you the room to take in folks if, for example, there's a surge of detention suddenly. And we're nowhere near that. We are far, far away from that. And all of this is, of course, playing out against a situation in which we're not staffed where we want to be either. And we're working hard to address that, but that is a function as well.
I know folks have some commitments that they have to go to, but I wanted to at least put this issue on the table because it will be discussed more in depth, I'm sure, once the session begins, because there's a lot of concern about it, but I also wanted members here of the Justice Committee to be aware.
Thank you.
That it's percolating out there.
Thank you, Madam Chair. I appreciate the chance to share that. It's obviously something that affects our thinking every single day.
Anything else?
Having us, Madam Chair.
Thank you. Thank you. So our next meeting is December 15th. We'll work with somebody in Ledge Council to do the schedule. We can go offline right now and we'll see everyone on December 15th. And Ginny, we'll get in touch with you to figure out when we're going to have a Zoom meeting.